my day-to-day work is so wrapped up in this whole notion of the nation state. Yet, in this area, when you have actors like ICANN or the IETF, the Internet Engineering Task Force, or the W3C Consortium, World Wide Web Consortium, you're dealing with very important players who are stateless, and they have to be part of the discussion, and they have to be part of the discussion on a level with the states. Now, for the states, for the nation states, this is a very difficult pill to swallow, because they don't want to cede any of that sovereignty, if you will. But I think what it does mean is that obviously in the internet area, there'll be these different mediations, but I think that this model of multi-stakeholderism, and this is going to go a bit beyond the informatics discussion today, if you think about applying multi-stakeholderism to other global problems, like climate change, for example, how would that work if the climate change discussions weren't just intergovernmental? What if it had industry there? I mean, I know they do, but what if industry was there as part of the official part? What if the NGOs and the academics were also there? I think that the way in which the debates would occur would be very different. The way in which information is shared would be very different. So what we see internationally in the cybersecurity internet governance space is a huge amount of resistance to this sort of top-down approach where governments make decisions and then it filters down through society. In the internet governance space, in the cybersecurity space, a lot of it's coming from the bottom. Some of it comes from the sides, and it's a very kind of three-dimensional, organic approach. But at the end of the day, I think it's what's required in this space. And with that, I thank you and open it to questions. I'll repeat the question for purposes of the recording, and I'll try and compress it. Let me know if I get it wrong. The question was, in respect of the new GTLDs and the example that was given about .god, what if someone wanted to register .allah, and if there were community objections to that kind of registration because the community thinks it shouldn't be there, how would that be resolved? Or that registration shouldn't occur. Is that the question? Yeah. The question was also, I think, bound up in this concept of bottom-up multi-stakeholderism. Part of the 300-page guidebook that ICANN produced is aimed at dealing with those problems. And that is among many thorny ones that will probably have to be worked out. There are processes in the guidebook aimed at resolving some of those issues. What I think the question points to is, even in a mechanism like, even in an environment like what ICANN has produced, has it adequately captured all of the community concerns, or has it put in place processes and mechanisms to capture those concerns? So that if there are people who would object to that kind of registration or any registration, would they know in a timely fashion that a registration or an objectionable registration has been made? Would they then be able to voice their objection, and to whom, and what are the recourse and modes of appeal to that? And so on the one hand, I think the problem is one of asymmetric information. So there's this pretty tight community, ICANN and all those people around it that understand this stuff, and they've set rules that they think are going to be okay, but they've got all the information, and people who don't have information might even not even know, A, that it's happening, or B, what to do about it. So I think after the application window closes in April, there's a review period of a few months. The Government Advisory Committee has the right to review every application as it goes through the process. So one of the mechanisms will probably have to be that some government member of the GAC will have to take it upon itself to make that kind of objection on behalf of a constituency or a community that they represent. I think it's the application period is only the beginning of the story. I mean, the review period and then what happens after that is going to be very important.
How far down does this go in terms of content? I noticed that you have a covenant. Does the covenant cover such things as accuracy and truthfulness in what's in the content on the site, or is it domain? Enforceability and that sort of thing.
The Covenant on Civil and Political Rights? Yeah, let me get back to that. So the question was, how deep does this right apply? And if I understood the question correctly, you were talking about websites and things like that. Well, the right applies to people, to individuals. So, and the question also involved, truthfulness, accuracy, and that sort of thing. Well, I can't give you a legal opinion on it, but I would say that it doesn't. It's the freedom to impart information is pretty broad, and I don't know that there's any interpretation of that.
I think what I was getting at was, this may come up later, people online put information about other people out there that's totally incorrect.
Well, okay, so the follow-up question was about how to treat inaccurate information in a data mining context. Some countries have libel and slander laws, and I think those would probably kick in at that point. I don't think that that this right is addressing that. There's a question in the back. Yep.
Is there one that has proven, or I guess a combination of dimensions that have proven more effective or most effective?
So the question was, of all these legal dimensions that have been introduced, is there one that is more effective or more useful? Yeah. No, I think the point is that if you try to apply, the constitutional analysis to infrastructure liberalization, it just wouldn't work. So I think it's very case specific. And likewise, if you apply just a legal and regulatory approach, as you would in infrastructure liberalization, to the area of critical infrastructure protection, it just wouldn't work, because one has to realize the nature of the problem that one is dealing with, and then try and find the right solution or the basis for the solution that you're trying to accomplish. And the point really is that when you're approaching legal reform from a holistic standpoint, it's not just a simple kind of cookie cutter approach, that you have to address these things as they come up. Yep.
I'm interested in having you expand on that intersection and the tension between the trademark protection for each country versus the new opportunity to file for the generic public review.
Right. Okay. So the question was to expand a little bit on the issue of trademark protection in the context of the new GTLD applications. Yeah. The guidebook that ICANN has produced sets forth a number of protections or exceptions for trademark owners. And I'll just give you the example from the World Bank, so it's easiest for me. We have a number of marks that we hold registered. If someone tried to register .World Bank, one of the defenses that we would have, according to the guidebook, is what's called a legal rights defense, meaning that if we would have to prove that we had a legitimate ownership of the mark and that we're using it, and that would give us not absolute rights, but kind of peremptory rights against the person trying to register it. I'm not a trademark lawyer. I'm sure there are trademark lawyers here who could expand on that further, but it's, as I recall correctly, the legal rights defense is a registration-based defense, not a use defense. So the registration is key. And we, as a result, have scoured through our institution to find out all the different registrations that might exist. We've tried to make sure that they're current. We found a couple that were important that weren't. We had one problem with a mark that we had that had the word "the" in front of it, and the domain wouldn't have "the," the domain would be World Bank, but our mark is "the World Bank," and so we're having a discussion about that. The other related problem, I think, is cyber-squatted domains. And to the extent that those might be out there's nothing in the guidebook that says this, but to the extent that there are cyber-squatted domains, and in our case, we know of about 300, how does it affect your legal rights claim if your mark in other instances has been squatted, but you haven't done anything about it? We don't know the answer to that question, but we're trying to preempt that by cleaning up those registrations. Now, we're not going to do all 300 at once. We're going to prioritize them and do the main ones first, and then kind of work our way down the list and see what kind of problems we have. But it's pretty scary. So if you're an organization who depends on your brand, I think the brand world will change as a result of these new GTLDs. George?